Welcome everyone. We're just about to get started here. Can you all see the presentation, the slides? Okay, there we go. Just going to wait another minute for everyone else to join, and then we'll go ahead and get started. Thank you, Jessica, for letting me know that everyone can see and see the slides and hear me, which is the main thing. So I launched a quick poll before this session just to get a sense for how new everyone is to estate planning. And let's go ahead and share. Yeah, these are the results. So most of the people on the call, half the people on the call are brand new to estate planning. And then we've got about 30% of you who've been sort of dabbling in it. And then the rest of you have been doing it for a while. So okay, so let's go ahead and get started, everyone. I am Laura Cowan. This is Estate Planning Essentials, Mastering the Basics. This is going to be about maybe a 30 to 35-minute presentation. I'm going to talk for a little bit, and I want you guys to be able to ask questions as well. So you'll notice that there's a place where you can enter questions. You can just type them in. And so go ahead and enter those as we're going through this, and I'll answer your questions live at the end. So a little bit about me. I'm Laura Cowan. I'm an estate planning attorney based in New York City. And I opened my law practice in 2016 from scratch, right? So I started with no experience in estate planning, no clients to bring with me. I didn't really have any kind of a financial safety net. But I launched in 2016. I only do estate planning, and it is now 6 years later, and I've got a 5-star estate planning practice that I've been running, and I'm going to teach all of you some of the secrets and some of the tips that I learned starting that practice and marketing it and making it successful. So I'm also the creator of a course called the 2-Hour Lifestyle Lawyer. 2-Hour Lifestyle Lawyer is about 1 year old. This is a course that was born post-COVID, and it's all about how to have a virtual part-time 6-figure estate planning practice. So we're going to talk more about that at the very end. So these are some of the awards that I've won. You can read through this list. This is really just to point out, this is the practice that I've built in the past 6 years, not really having any experience, not having any kind of a safety net, like I said earlier. And everything that I've learned in those 6 years, building my own law practice, I'm now sharing with other attorneys. I would love it if you would connect with 2-Hour Lifestyle Lawyer. We've got a website, we're on Instagram, YouTube, join our Facebook group, that's for lawyers and law students only. And this is my contact information, my email. So if you have any questions at all about anything that we're talking about today, feel free to message me. And you'll all get a copy of these slides at the end of the presentation as well. So don't worry about writing all of this down, but we would love for you to join our community. This is all about, again, helping lawyers launch and market an estate planning practice, even if you've never done it before. So this is our agenda, and like I said earlier, I'll probably talk for about half an hour, and then we'll open it up for questions. So type in any questions that you have in the question box, and I'll get to those at the end. We're going to talk about what estate planning is. I'm assuming that most of the people on this call are practicing attorneys, or maybe you're a law student and you know what estate planning is from the perspective of, what was taught when we had to study for the bar, or maybe what was taught in a class that you took. I took a class in estate planning when I was in law school, and it didn't really prepare me at all, to be completely honest, for what I have to do on a day-to-day basis in terms of running my firm, etc. So we're just going to talk about the very basics, like plain English, what is estate planning and why your community needs you. We're going to talk about the basic estate planning documents that you'll be preparing for every client. This is a document preparation sort of practice, but really we want to get beyond that. We want to get into the counseling and how you can make yourself a valuable resource to your community. All of those things that separate us from LegalZoom and from, I can't believe I'm even saying this, but ChatGPT. But just what are the documents that you're going to be preparing? We'll talk about that. I want to talk about what you can charge. If there's people on this call that are brand new to estate planning, you might be wondering, well, if I add this as a practice area, what's that going to look like? What can I charge for an estate plan? How does that look? And so we'll talk about that. And of course, it's going to vary based on where you live and your market and all of that. But I just want to give you a sense for what you can charge and how you can package your services in a way that they're going to be attractive to prospects. And then I'm going to talk a little bit about the 2-hour lifestyle lawyer course and coaching. And again, this is a course that I've launched to help attorneys launch and market a virtual part-time 6-figure estate planning practice. We've moved about 200 lawyers through the course already, and we would love to have you join us. But either way, hopefully this presentation will give you just some nuggets of information that are going to be helpful to you. And I'm just assuming that you're starting from ground zero, okay? So this might be a little bit basic for those of you who've been doing this for a while, but let's just start with what is estate planning. So this is the process of organizing and arranging your assets, your properties, your affairs during your lifetime to make sure that things happen the way you want them to happen in the event of your incapacity or your death. So it's not just about who gets what when I pass away. And this is one of the first things that you're going to want to counsel your clients on, is there's a lot more to the estate planning process than just saying, I want all my assets to go to my kids in equal shares. Okay, and the better you get at this, the more business you're going to get, because you'll find that your clients and your prospects are coming to you from the perspective of, can I just do this on LegalZoom? And isn't everything just going to go to my spouse anyway, right? So it's a lot more than that. And this is something that we focus on in the course, is educating your prospects and your clients. So it does involve creating legal documents, right? And we're going to talk more about these, but wills, we all know what a will is. A trust, many of us don't know what a trust is. We'll talk more about that. A power of attorney, healthcare directives, appointing guardians for your minor children, guardianship documents, right? Long-term guardianship or permanent guardians, and part-time guardians. All of these things are going to be decisions that your clients are going to make, and then they're going to formalize them in the legal documents that you prepare. So the primary goal of estate planning is to get it in writing, right? What would you want to have happen to your assets, to your family, to your health care in the event of your incapacity or your death? And so we're talking about who's going to take care of your minor children, where are your assets going to go, and under what circumstances. It's not just naming a beneficiary. Name your 18-year-old son as your beneficiary on your life insurance policy, and he might get $1 million that he spends, overnight. Maybe it's better if he gets the $1 million, but he gets it staggered or in some kind of a trust. Avoiding estate taxes, avoiding probate, avoiding family conflict. There's a whole slew of issues that, as lawyers who are professionals at issue spotting, these are going to be the things that we're going to discuss with our clients. But the whole idea here really is to show our clients what's going to happen to your healthcare, your finances, your family in the event of your incapacity and death if you don't have any estate planning in place. And then you're going to show them, after they've told you, well, what don't they like about that? Do you really want a judge naming guardians for your minor children, or would you rather get it in writing that you want your sister to be guardians of your minor children? Right? You have to identify the things that they don't like about where they are now in order to show them where they're going to be after they've hired you. And this is key, and this is something that I spend a lot of time talking about to our members and in other presentations. You're going to find when you start to add this as a practice area that this isn't like personal injury or criminal defense, two areas that frankly I've never practiced in, but I would imagine it's very different in the sense that people come to you in pain. With estate planning, people aren't coming to you in pain. They know that they should have an estate plan, but it's not all that fun writing a check for it. So to the extent that you can show them sort of where they are now and where they're going to be after they've hired you, then you're going to have a much better time getting clients. So for you as the attorney, estate planning is not just document creation. And the sooner you understand this and are able to convey this to your prospects and your clients and your community, the more business you're going to get. This is what's going to set you apart from LegalZoom and ChatGPT, and God only knows what else will come out later. Okay? Your role as the lawyer, yes, the final product is going to be a stack of signed documents. But really, the value that you're providing is in the counseling. It's in the advising on what should go into the documents based on your client's specific set of circumstances. It's just like law school. Every case has got a different set of facts, and then how do you apply those facts to the law? This is what people are paying for. And this is not going to be replicated by LegalZoom and ChatGPT. Okay, now I'm a big fan of AI, by the way, ChatGPT for marketing. So that's just an aside. There's a big place for AI in law firms, but it's not going to replace us. And that's because only lawyers can do that legal analysis that your clients are going to need. You're making sure that the documents are signed with the proper legal formalities, that they're staying up to date, that you're a trusted advisor in the long haul. Maybe you implement a membership or a maintenance program in your firm, and your clients know they can come to you in the future, and they should come to you in the future, because estate planning is not just something that you do once and then never think about again. Okay, so that's sort of a broad overview of a very, very broad overview of estate planning as a practice area. I want to talk a little bit about why I think this is such a unicorn practice area, especially because of number 5. But all of these are benefits of estate planning. First, you can bill a flat fee, and you should bill a flat fee, right? You shouldn't be charging by the hour for your services. A basic will package in your state or a basic trust package should be a flat fee, and you're going to collect it all in advance. So there's no hourly billing, there's no chasing down clients for payments. I don't have any accounts receivable in my firm, okay? Because people just pay me up front, and that's the end of it. If people balk on paying the entire thing up front, maybe you take half in the beginning, half 1 month later, okay? But it's gonna be a flat fee. You've got complete control over your schedule. This is one of my favorite parts about being an estate planning attorney. And I think I was just getting off a call for 2-Hour Lifestyle Lawyer with a couple of women who I hope are now on this call as well, listening in, but I was mentioning to them something that they hadn't even thought about, and that was I open up my calendar online on Calendly from 9 a.m. to 11 a.m. And I open up that block of time for clients to book meetings with me. And that's the only thing that I make available. And I think a lot of lawyers haven't thought about, you don't have to open up your calendar from 9 a.m. to 5 p.m., right? It hasn't occurred to a lot of us that you don't have to do it. Set up your calendar online, have a link for clients to book meetings with you, and then open up the hours that you want to work. Maybe for you, that's 9 a.m. to 3 p.m. and you're going to be done by 3 p.m. because then you've got to go pick up the kids from school, right? You get to pick, but you're not tethered to the court calendar and you're not tethered to a 9 to 5 either. Okay, I hope that makes sense. If you guys are having questions as I'm going through this, drop them in the questions box. Okay, so you've got complete control over your schedule. It's easy to put systems in place. And one other thing that I'll say about the schedule is that you can also manage this so that different meetings happen on different days. So for example, I host signing ceremonies at my office, but I don't want to be doing signing ceremonies willy-nilly throughout the week, right? Because you've got to find your witnesses and your notaries and all that. So I only open up a couple of Fridays per month. So some meetings, the consult, for example, I'll have those 4 or 5 days a week because I want to get the new business. But the signing ceremony, I'm only gonna give people a couple of days per month for those, right? So these are some of the things that you can think about to control your schedule. Systems. Lawyers who have systems in place with estate planning are definitely going to be able to get to their 2-hour lifestyle lawyer mode, which is working a couple of hours a day. It's easy to put systems in place with estate planning. And what that means is that you're going to move everybody through the same process. They're going to go to the same meetings. Each meeting is going to be the same amount of time and have the same agenda. They're going to be able to book things online, automation. Now, I'm not saying that when you get to the point where you're giving legal advice or you're drafting carefully tailored legal documents, of course, those are not going to be, cookie cutter. Those are not going to be cookie cutter, but the process, the system, that can and should be cookie cutter, and it benefits your clients just as much as it benefits you because they know what to expect and there's no confusion. This is the perfect practice area to do part-time, okay? You do not have to build $1 million law firm. I feel like nobody had told us that, and this is something that lawyers are only starting to realize post-COVID. Now, if you want $1 million law firm, that is fine. That is fine. We'll help you get there if that's what you want. But if you want to work part-time, use your law degree to do very important work for your community that pays well and means you still have time to devote to your family and your friends and the other things that are important to you. This is a really great practice area. Now, it doesn't happen overnight. You need to build it up, right? It doesn't happen overnight, but it is possible to work part-time and make good money doing estate planning. And then number 5, virtual. This is not something that we could say 3 years ago. When I launched my practice in 2016, nobody would have ever hired me via Zoom and then written me a check for $5,000, having never met me at my office and had every meeting at my office. It wasn't what I call socially acceptable, right? We had the technology, but people just didn't do it. Well, that all changed literally overnight in March of 2020. And so if you're, I had a call today. There was a lawyer who's living in Florida, but she's licensed in California, right? She's going to be she's going to be servicing clients in California from Florida. That didn't used to be possible, now it is. And your clients won't mind to the extent that you're dealing with people like maybe young families or, anyone who's okay with doing things virtually, which is most people in 2023, you're going to be able to service people from a cafe in Paris is always my joke, from anywhere. That's a big deal, you guys. It means we're not tethered to the office. Okay, this is the market. We've got 330 million people in the country. I don't know exactly how many of these people are over the age of 18, but it's a big proportion, and eventually everyone's going to be over the age of 18. Every single one of these people needs your services. And most of them don't have an estate plan. And if they do have an estate plan, it's either outdated or they've moved states, or they can't find their lawyer who did the estate plan because their lawyer didn't have any systems in place to keep in touch. I do a lot of business for people who already have an estate plan, but they haven't heard from their lawyer in 10 years, which is bad news bears, right? everybody needs your services. Now, it doesn't mean that it's easy necessarily to get the business. You do have to get over that hurdle of why can't I just do this on LegalZoom? Why can't I just do this myself? Why do I even need an estate plan? But these hurdles can be gotten over with marketing and nurturing and webinars, just like the webinar that I'm doing now with all of you, educating your community, right? There's always going to be that subset of people who will never hire an attorney for this, but there's a lot of people that want to work with a qualified attorney who makes the process easy and understandable and relatable. Once you nail that down, once you dial that in, it's going to be a lot easier getting people to hire you. Okay, it's a big part of what we teach in our course. I've got 9 sort of target markets for you to think about. I want you to start to think about who you want to serve. And the reason this is important is because your marketing, to the extent that you market your services in your community, it can't just be for everybody, because then you're not going to speak to anybody. So you want to think about maybe 2 or 3 groups of people that you want to serve. Now, it doesn't mean that other groups aren't going to fall in your lap. I mean, I don't market to high net worth individuals, for example, but it doesn't mean that they don't call my office and I get them as a client, right? But I market to parents of minor children, and we'll talk more about this. So here's some of the groups, and there's 9 total. Senior citizens, people over the age of 55, 65. If you're interested in elder law, Medicaid planning, that can be a really lucrative area of law. So senior citizens. I don't do elder law, I only do estate planning. Parents of minor children, this is my target audience. This is a great audience to market to for a couple of reasons. One, they're really motivated. I think they're even more motivated than people in their 90s, because there's nothing more important to them than, you know, God forbid something happens to me, who's going to take care of my children? They're also very happy to do everything via Zoom. They're very tech savvy, which makes things easier if you want to be virtual. Business owners are an amazing group of people to network to. If you're on this call and you're already doing business law and serving small business owners, this is a great area for you. Estate planning is a very, they go well together. So the other nice thing about business owners is that oftentimes they're used to working with attorneys, right? They're already working with an attorney to get their LLC set up or to get their trademark in place, right? So to the extent that you can add this on as a practice area, you're gonna get a lot of business. High net worth individuals, this is for those of you who want to do the more complicated, irrevocable tax planning. This is for people who, that right now the federal estate tax is on estates more than about 25 million. I think about 13 states have an estate tax. New York is one of them. This kind of planning is more complicated, and you can definitely charge a pretty good fees for it as well. Now, if you're not interested in estate tax planning, that's okay. If you get a high net worth client, just refer them out to an attorney who's experienced and take a fee split. Blended families have got their own unique issues. Second marriages, stepchildren, half siblings, all the things that go along with that, right? This might be a good niche for you. People who have children with special needs. This is important if you have a child who has special needs and they don't, you don't necessarily want to give them an inheritance outright, because that inheritance might disqualify them from benefits they're otherwise entitled to. So I know quite a few attorneys who themselves, within their own family, they have a special needs dependent and they're familiar with this community, and they do a lot of special needs planning. This is really important work. Unmarried couples, you're always going to get the question, I'm not married, why do I need an estate plan? It doesn't matter. And in fact, I think it's interesting that estate planning for people who aren't married, and for those of you who are on the call who've been doing this for a while, you'll agree with this probably, their estate plans are oftentimes more complicated than married estate plans, because they're leaving certain amounts to charity and certain amounts to family, and it just isn't, everything goes to the spouse. A lot of my clients are not married. You need to have those healthcare protections in place. There's a lot of things that matter. And then if you are in a couple but you're not married, then you want to make sure that you've got planning in place to account for rights that you maybe don't have that you would have if you were married. If you're in any way interested in donating to charity, you have to get it in writing, right? It's not going to happen unless you get it in writing. And if you have charitable intentions, oftentimes this goes well with people who have a taxable estate, right? You have so much money that you want to give a lot of it away. And there might be a tax reason for that, and it might just be because you have a lot of money. And then end of life wishes, elderly people who've got specific healthcare wishes is another group. So think about these groups. Again, it doesn't mean that you're not going to work with people in more than one group, but just remember that when you're tailoring your marketing, when you're hosting workshops in your community, you want to pick one or two of these groups to tailor, because you can imagine that each of these groups has different concerns and different pain points, right? So that's just something to consider. Okay, let's talk about the documents that are going to be in every estate plan. Again, this is for people who are really new to estate planning. Every estate plan is either going to have a last will and testament or something called a revocable living trust. I think we're all familiar with what a will is. I don't really need to go through this. If you've taken the bar, you know what this is. You're going to nominate your executor, guardians for minor children. You're going to nominate beneficiaries for assets that don't already have a beneficiary designation or aren't already jointly owned. Now, the downside of a will that I actually didn't know even after I graduated law school, but I know now, obviously, is that they have to go through probate court, right? And there's some downsides to probate court. Depending on what state you live in, they might be pretty bad. New York, California tend to be pretty extensive probate processes. Maybe if you're in another state, probate isn't that bad. But in any event, a will is going to be one option that you're going to go over with your clients, and you're going to talk to them about what a will looks like in your state and the pros and cons. Again, it doesn't cover every asset either. And it's something that's jointly owned. It's just going to go to the joint owner. Life insurance is just going to get paid to the beneficiary. A big part of what I talk about in my 2-hour lifestyle lawyer course is a revocable living trust. And this is not to upsell people to a trust that they don't need. I spend a lot of time talking about pros and cons of wills in New York, and then a lot of times talking about what a living trust looks like. And then ultimately it's up to the client to choose. A living trust, in a nutshell, it's like a will, but it avoids the time and the expense and publicity of probate court. So if you have a living trust and all of your assets are owned by your trust, then your client's going to avoid probate. And maybe that's important to them, and maybe it isn't. It's something that they're going to decide. So it's basically a legal entity that's going to hold the assets on behalf of the beneficiary, managed by the trustee, which is your client during their lifetime. And then when they pass away, they'll pick a successor trustee to administer the trust. Most of my clients in New York choose a living trust over a will because they're trying to avoid the downsides of probate. And sometimes that downside is that they just want everything to be private. They don't want their will becoming public when they pass away. Having said that, it's your job as the attorney to explain both a will and a trust, and then let your client decide. And they're much more likely to hire you if they're the one deciding what they want or need, as opposed to you telling them you don't need this or you don't need that. Okay, you're also going to do healthcare documents. These are necessary in the event of incapacity, right? The will, the trust, those are for what happens when you pass away. Well, what happens if you're alive but you can't make your own healthcare decisions? Every state's got their own healthcare proxy. It may or may not include a living will and a HIPAA waiver. It's just going to depend on your state. But this is for your client to choose an agent to make healthcare decisions for them. If they can't communicate them themselves, oftentimes they'll choose a spouse, but it can be anyone over the age of 18, at least in New York. And then you can pick your backups, right? Oftentimes people will choose their adult children as backups. Healthcare documents are also going to include a living will if that's what your client wants, and that's basically an optional document that basically says, in the event I'm in a permanent vegetative state or have some kind of a terminal illness, I'd like to be removed from life support. A HIPAA waiver This is giving certain people permission to speak to doctors on your behalf. And then final disposition instructions. Do you prefer burial? Do you prefer cremation? Who do you want to be in charge? What special wishes do you have? Okay, so these are going to look a little bit different in every state, but these are very important. And then a power of attorney. This is another document that you want to have in the event of your incapacity. It's like a healthcare proxy, but it's for your assets. Who's going to pay your bills if you're incapacitated? Who's going to file your income taxes? Who has permission to go and deal with your bank? This is a very powerful document. You want to make sure that you really understand what this is, because you're giving, your client's going to be giving their agent a huge amount of control over their finances and their property. So this is one that you definitely want to get right. Most people nominate their spouse again, but you can choose whoever. And if you have adult family members, maybe they'll be a backup. Adult children. The power of attorney can be effective immediately upon execution, or maybe it can be springing, right? So it's only effective in the event that I'm incapacitated and I actually can't do these things myself. So these are going to be counseling points for you and your client. Okay, so that's a very quick rundown of some of the basic documents. And one thing that I want to make really clear, especially for the people on the call that are new to this and they haven't done any estate planning, there's drafting software that's available that is going to help you create state-specific, very professional, comprehensive estate planning documents for your clients. And this is good news, you guys. When I opened my practice in 2016, I didn't know initially that this existed. And when I found out, I was so happy, because this is what makes you able to hang your own shingle, right? You're going to be using the same drafting software that the big firms use. You're going to be providing as comprehensive and as professional an estate plan to your clients as the big firms, right? It levels the playing field. It also, these, especially wealth docs and interactive legal, they've got training, they've got education, they've got community, they've got events. This is going to be a one-stop shop resource for those of you who are new, and even those of you who aren't new. You know, there are people who've been Wealth Council members for 20 years because it is so valuable. What this means is that you're going to get basic information. You're going to do a design meeting with your client, and you're going to counsel them on their options and get all the information that you need. And then you're going to input that information into the drafting software for your state. Or better yet, you're going to outsource it to a virtual paralegal. I use back office drafting. Jessica, I don't know if you're able to add things into the chat, but if you can drop the link for back office drafting into the chat, that would be great. So what I'm really trying to get at here is that if you're thinking about adding this as a practice area, you're not going to have to cobble together estate planning documents using Word, copying and pasting based on what you can find online. There's drafting software that's going to help you. So this is kind of a comprehensive list of all the things the drafting software will generate. And I don't even think that this is everything, but it's going to generate either a last will and testament or a revocable living trust and an accompanying pour-over will, declaration of trust, a certification of trust, your power of attorney, your healthcare documents, final disposition, trust funding instructions, personal property memorandum. This is when you itemize, the engagement ring goes to my daughter, the wedding ring goes to my son. If you want to itemize any personal property, these aren't valid in all states, but if you want that, it's part of the software. Standalone guardian nomination outside of the will. The will's only effective when you pass away. What happens if you can't take care of your children because you're incapacitated? You want a standalone guardian nomination for that instance. Testamentary trust. Testamentary trust is, instead of saying your kids get everything outright at 18, you say, well, no, I want them to get a third at 21, a third at 25, and a third at 30. Okay, that's a testamentary trust. I see one question, what goes in a pour-over will? Great question. When you have a revocable living trust, you do get a very basic will that goes with it. Now the will, the only beneficiary of the pour over will is the living trust, but what it does is it captures any assets that you may have forgotten to move into your trust during your lifetime. And it'll pour those assets into your trust at your death. Now they might have to go through probate, but at least they'll be distributed according to the terms that you set out in your trust. Okay, so that's a pour over will. And it also means that you're going to nominate guardians for your kids in the pour over will. Okay, so if someone does a revocable living trust, they're also going to get a pour over will. Okay, summary of estate planning provisions, summary of fiduciaries, all the things that you're going to bundle together. You're going to have your client sign everything, and then you're going to present them with a very nice professional binder with all of their signed documents. This is the one tangible thing that they take with them. I spend a lot of, I wouldn't say a lot of money, but I buy nice binders, and I really try to make this binder process sort of a ceremony kind of thing. You know, this is the thing that when you hand someone, you're like, yes, you gave me $5,000 instead of going to Disney World, right? This is the tangible thing that you're taking away. And the drafting software is going to help you create all of this. All right, what can you charge? This is a very simplified version of my fee sheet that I share with my 2-hour lifestyle lawyer students. We've got several fee sheets that you can choose from. The 3-tiered fee sheet, okay? You see it everywhere. My assistant said the other day, she's like, there's a 3-tiered fee sheet at my nail salon, okay? The idea here is, 1, you're gonna be charging a flat fee. 2, you have to have a fee sheet. You can't just blurt out a number at the end of the meeting, right? It is, again, it's a hurdle to get people to hire you, especially for these dollar amounts, right? So people need something to look at. They need to understand what they're buying. And number 3, you don't want to have an a la carte fee sheet. Okay, it's just going to confuse people. I have an a la carte fee sheet after someone has hired me that shows this is how much it costs if you want to make modifications, and this is how much it costs if you want to, you know, update your will. Then I have an a la carte fee sheet for updates. But when someone's coming in for a consultation, I give them a 3-tiered fee sheet, and usually the tiers are a basic will plan, if people just want a basic plan without any probate avoidance. New York City, 2,500, 3,000 is frankly probably on the low end. Trust plan. This is the plan that most people choose. This is your revocable living trust. This is for people who want to avoid probate and get some other benefits that you get with a living trust. Again, this is a number for New York City. It might be less where you live, but you know, I've got members in Wyoming that are charging $5,000 for a trust, and that's in Wyoming. California, New York, you're going to be able to charge a little bit more, but the point here is these numbers are realistic once you're able to communicate the value of the services you're providing, and that's something we teach in the course. And then you want to have a third option, and what goes in that third option is going to depend. Maybe you charge a little bit extra because you'll do the trust funding for your clients. Or maybe you charge extra for people like in New York, if you've got more than $5 million, it's a taxable estate, and we're going to have to do some irrevocable tax planning, and maybe the fee for that is going to be at least $8,000. Most people are not going to pick or want the third option, but I want you all to remember this. You have to have the third option because it makes the other two look more affordable. Okay? And some people will choose it. You always want to have a platinum option because there's going to be a few people who actually want it, right? But go ahead and put it there because it makes no one wants to buy the most expensive package. So the 8,000 or whatever number I have, yeah, 8,000. It makes these two numbers look more affordable. 3 options. You give people more than 3 options, and they're confused. And now that I've mentioned this to you, you'll see this everywhere. Everywhere you go, there's 3 plans, right? There's no guarantee that you'll be able to charge these numbers where you live. Maybe you're charging more. I know lawyers that are charging more, but I just want to give you a sense for kind of what is possible and how to present your services. Okay, so I'm almost done. I see we've got some questions in the chat, which I'm going to get to in a minute. I want to take a couple of minutes and talk about our 2-hour lifestyle lawyer course and coaching and community. So this is a program that I launched about a year ago, post-COVID. It's to sort of meet the demand of lawyers like all of you on the call who maybe want to add estate planning as a practice area. You almost certainly want to work virtually, and many of you want to work part-time. And this is the perfect practice area for that. This is the bucket that I'm in. I work 2 hours a day. I make about $30,000 a month in estate planning, and I'm doing it all virtually, right? So I've taken what I've figured out in the past 3 years post-COVID, and I've put it into the 2-hour lifestyle lawyer course and coaching. If you're new to estate planning, that's okay. About a third of our members are brand new. And I always like to reiterate that I had never done a will when I hung my shingle in New York City. Okay, and that's not to say that there isn't a learning curve. There is a learning curve. You are going to have to learn the law, right? You are going to have to take the CLEs and to take the courses. That's what Wealth Counsel is for. That's what Interactive Legal is for. There's a lot of resources. But I don't want you thinking that you can't start to do this and start serving your community doing something that they really need just because you've never done it before, right? That's what this course is about. So in a nutshell, we've got 10 training modules that sort of take you through from the minute you get a lead all the way down to they've signed their estate plan. We have live group coaching. One of our group coaching calls every week is with a practicing estate planning attorney. She coaches you for the newbies on estate planning. It's her job to teach you estate planning, okay? We've got a VIP Facebook community, and we've got an ongoing membership. If you want to lock in a year of coaching, you can do that. It's called the Lifestyle Lawyer Collective. So this is what the course is in a nutshell. Again, we've got lawyers brand new to estate planning. We've got lawyers who want to work part-time. A lot of lawyers who want to learn how to do this work virtually. Closing someone and servicing someone over Zoom is different than it is having someone come to your office. A big part of our program is teaching how to get business by hosting webinars. That's something that I haven't mentioned at all on today's presentation, but that's going to be a tool in your tool belt that is going to allow you to get business without having to rely on referrals and luck and people just finding you online, right? Educating your community is a big part of being successful as an estate planning attorney. So we teach you how to get business by hosting webinars or in-person seminars if that's something that you're interested in. I go into much more detail about what's in the course in our discovery calls. So these are calls that I host. They're via Zoom. We usually have between 2 and 5 attorneys on each one. We'll talk about what's included in the course, what the investment is, and if you'd like to enroll, that's great, and if not, that's fine too. Hopefully we can be a resource for you in some other capacity. Definitely join our Facebook group, follow us on Instagram. We're getting YouTube up and running, but really the goal here is to help lawyers build a practice that is a lifestyle practice, right? That's really the goal here. We're not here to help you build $1 million law firm, but we are here to help you build a lifestyle practice. So I see we've got some questions. This is amazing. I'm going to go through these now. Drop them in the chat, you guys. If you have more questions, just drop them into the questions box. Okay, so someone is asking, Jennifer, with no interest in doing elder law planning, where do you draw the line in taking on a new client? Determining if they just need straightforward RLT will or if they're going to need Medicaid. Yeah, so that's a great question, Jennifer. This is going to depend on their age and sort of how many assets they have. What I find with people in their, 50s, 60s, in terms of the Medicaid planning, is they're either going to have, so little money that they're going to very easily qualify for Medicaid, or they have enough money that now you're into the taxable estate territory. It's the people who are sort of in between that might need Medicaid planning, people who have maybe $1 million in assets, but it's all in a home, and you could easily put that home into a Medicaid asset protection trust. So if I get the questionnaire back, Jennifer, and it indicates a scenario like that, I will co-counsel that or refer it out to an attorney who does Medicaid planning. And I will get a fee split for that, according to the rules that are allowed. Okay, because I'm not interested in doing that kind of planning. Now, if you are interested in it, then by all means, you can take on that client. But it's okay, and I want to make this clear, you don't have to learn how to do elder law Medicaid planning if you don't really want to. You want to get used to the idea of saying, yes, I know I could charge $10,000 for a Medicaid asset protection trust, but am I really interested in that? And if the answer is yes, then great. But if the answer is no, then see if you can co-counsel with another attorney who's more experienced with that and get a fee split. So Fred is asking when to raise with the client to consider an asset protection trust. So there's different kinds of asset protection trusts. If you're trying to protect assets from, creditors, then that's one concern. Another concern is I'd like to set up an asset protection trust for my children. So I almost always bring up asset protection trusts for the children. So in other words, instead of leaving your children $1 million outright, you set up an asset protection trust for them when you pass away. And that's going to protect their inheritance from bankruptcy, lawsuit, divorce, while still giving them access to it. Asset protection trusts for people that they want to put in place while they're alive for their own assets is kind of a different story, and that makes sense for people who have quite a bit of money, and that's sort of a separate area that maybe you can specialize in, Frank. Jennifer, we've already talked about what goes in a pour over will. Also, Jennifer is asking, aren't there some assets that cannot go into a pour over will? I'm sorry, some assets that cannot go into an RLT. Virtually every kind of asset can be transferred into a living trust, right? But I think maybe what you're getting at here is, something like life insurance. You don't put the life insurance into the living trust. What you do is you name the living trust potentially as the beneficiary, right? So your retirement assets, you wouldn't retitle those into your living trust, but you may or may not name the living trust as a beneficiary, although that gets a little bit complicated. So that's a big, it depends. But when you're just thinking about assets like artwork or an LLC or a car, virtually, and a trademark, these are all assets that can be moved into a living trust. Ellie's asking, how do I differentiate between single married clients for a fee? This is a great question. So I've got one fee sheet that I pull out when I'm going over my fees. And then at the end, if I'm speaking to someone who's not married, I might say, and the fee for you, since we're doing just one set of documents, is going to be $500 less. But I don't mark that on the fee sheet. And I don't mark it down much more than 500 because, and for those of you on the call who know what I'm talking about here, oftentimes the work that goes into an estate plan for someone who's not married is just as intensive because they've got a lot of specific distributions and things like that. So I'll do maybe 500 less, but no more than 500 less. I certainly don't chop it in half. So Melissa's asking, how does my model take into account rules lawyers must adhere to from other states? So I'm not 100% sure what you're asking, Melissa. If you could be a little bit more specific. I'm wondering if what you're asking is, are you allowed to sit in one state and practice law for clients in another state? If that's what you're asking, the answer to that is the state that you're sitting in has to say it's okay. So in other words, if you want to sit in Florida and live in Florida, but you're licensed in New York and you want to be able to do estate planning for clients who are in New York, then it's Florida who's going to be the one who says, yes, you're allowed to live here, but practice in New York. That's my understanding of the recent rule. So, it might be okay for you to sit in Florida and practice in New York, but maybe Montana has a different rule, right? You have to look at the rule that's in the state that you're actually physically present in. How much malpractice insurance coverage should someone get if they're just starting and are looking to work part-time, making $100,000 to $200,000 a year? Yeah, that's a great question, Sonia. You definitely want to get malpractice insurance for this practice area. Now, how much you get, I can't really say. We do have a module in our course that talks about malpractice insurance. That's going to be one of the bigger expenses that you have in terms of getting set up. I should just take a step back and say, you know, setting up your practice, there's going to be a few things you're going to want to invest in. Definitely malpractice insurance, something like wealth counsel or interactive legal. Those are going to be the big ones. You don't necessarily have to have office space. You can get by with a part-time virtual assistant, right? Decision vault is what you want for your intake questionnaire. There's going to be some things to invest in, but I can't really say how much malpractice you should have. But I can, Sonia, give you the name of a good broker. So email me if you need that. If you're an attorney licensed in Minnesota, and if you are licensed in Minnesota, Melba, that's where I went to law school. I went to the University of Minnesota Law School. But you live in the DC area, would you need to waive into DC to create estate plans for clients locally? Yes, definitely. You can't serve a state that you're not licensed in, no matter where you live, right? So if you live in DC and you want to service clients in DC, then you would need to waive into that. Oh, you went to the University of Minnesota as well. That's amazing. Yeah, you need to be licensed in DC. So I don't help, you know, with that, but what I can help you with, Melba, if you're living in DC and you're licensed in Minnesota, we can certainly help you get clients in Minnesota and serve those clients without actually having to travel back and forth. Right, that a lot of lawyers in our program are doing that. Which, and I like to really point this out, you guys, we couldn't have done this 3 years ago because it wasn't socially acceptable to hire an attorney via Zoom, and now it is. So this is a real benefit. If you're licensed and you're living in a different state and you're not doing anything with your law degree, there's no reason why you can't start doing estate planning for people in the state that you're licensed in. Okay? All right. So do my flat fees go into my business account or my trust account? Yeah, that's a great question. This is going to depend. Oh, hey, Ellie, it's good to see you again. Yeah, this is going to depend on what state you're in, right? If you collect the entire fee in advance, what are their rules in terms of depositing that money? Is it earned? Is it not earned, right? Every state's going to depend. But what I will say in terms of collecting fees is either way, you're going to either collect the entire thing in advance and put it into your trust account if that's what your state says to do, or you're going to do half when they engage and then half a month later. What I don't want you to do is tie the second half of the payment to when they decide to sign the documents. Because if you do that, you're going to have a lot of clients who put off signing for a long time because they just don't make it a priority or they don't want to pay you the second half or whatever. And so you will have done 99% of the work and not gotten any, and not gotten that second payment. So at a minimum, take half up front, half 1 month later, and by that time you will have drafted the documents and the vast majority of your work will be done. And so you've earned that second half. Get the credit card, don't be shy. But yes, definitely follow your state rules in terms of what goes into a trust account versus your business account. Okay, so we've got a, what is this thing called? A QR code. Yeah, so scan the QR code or visit the link down here. I'd love to speak to all of you at one of our upcoming Discovery Zooms. If now is not the time for that, then please just follow us on social media or send me an email if you've got questions, and hopefully we can be a resource for you at some point in time in the future. Thank you all for joining. I really appreciate your time. I hope this was helpful. Yeah, I'll definitely, Barry, I'll send the slides to everyone. Yep, awesome. Thank you, Frank. Thank you, Melba. Always good meeting someone else who went to the U. Yeah, go Gophers, exactly. All right, take care, everyone. Have a great rest of your week.